Now, a Cape Coast High Court hearing the Assin North MP's dual citizenship case has dismissed allegations by the lawyer for the Assin North MP, Abraham Amaliba, that he has made comments that suggest he's predetermined the matter before him. Mr. Amaliba made an application before the court for the judge to recuse himself because of the comment he, the judge, Justice Kwesi Boakye, is alleged to have made in a previous sitting. This was strongly rejected by the judge, who says there's no record to prove the said allegations of bias against him, neither did any comments like that come from him. Now, the Assin North MP has been dragged to court over his qualification when he filed to contest the 2020 parliamentary elections. Nana Boakye is member of the legal team for the petitioner.
Okay, I mean, today we were expected to file our submissions, our written submissions. We have filed. Interestingly, and I mean clearly, we were expected it. The NDC did not file. Rather, what they have done is that they've put in two applications. One is supposed to be heard on the 18th. The other was heard in court today. Before then, we went to the judges' chambers. Now, what the respondents are trying to say is that in one of the occasions where the matter was being heard, the judge engaged him, and in one of the comments that he made, suggested that he had already predetermined the matter. So we also strongly rejected that position. We said no, that cannot be the grounds for which a judge should recuse himself from a particular matter. And that was the nature of the application being sought by the respondent. They said that because a comment was made and that comment suggested that the judge had already predetermined the matter, and then
now, Richard Kojo-Nyarko was in court and joins us via Zoom. Richard, which comments is the lawyer for the Assin North MP referring to, and how was it dealt with? Right, Richard, please unmute your microphones and tell us the comment he was referring to.
Well, so Daniel, two applications were made in court today, just as the lawyer for one of the legal team members of the applicant intimated, but that the justice that is sitting on this very case had made some comment, and the comment is that the judge is alleged to have said that the MP ought to have gathered all the documents he needed before filing the nomination processes with the Electoral Commission. And so this, Abraham Amaliba says, is unfortunate. It is bringing the likelihood of bias on the part of the judge. And so if it is not contested, it will occasion some injustice against his client. But that was strongly rebutted by the judge, who said that he has not made any such comment, and all documents in the court do not suggest so that a comment like that has been done. So there are no records in the court that suggest that has been done, and so that was dismissed. And then the second application was on the application for stay, and so lawyers for the respondent, the MP, filed the application to stay proceedings, and that will be determined on the 18th of May when the court reconvenes. And so that was how these matters were dealt with. Anyway, the lawyers for the applicant have filed their written submissions. The lawyers for the Electoral Commission have also filed their written submission, with the exception of the lawyers for the MP, who are yet to file their written submissions as well.
Right. So beyond
the proper time for the first respondent to have renounced his Canadian citizenship is at the time of nomination or at the time of elections. And so, in his comments or opinion, the judge had already determined that at the time of nomination was the proper time for him to have filed that. And for that matter, which means that once it didn't happen at that time, he was disqualified. And this is before the determination of the substantive matter. So the likelihood of bias is that this statement is prejudicial and does not conduce well to the administration of justice for the judge to continue being on the matter. And so that matter was determined. The judge said he could be fair and that it did not amount to bias and that he would proceed with the matter. But the date was fixed for us to come and move our application for stay of proceedings pending the appeal, after which the court will now give further directions as to how the case will proceed.
So what was your appeal on?
The appeal was against the judge's order that we should file.
So, Richard, was the Member of Parliament himself there?
No, the Member of Parliament hasn't been in court ever since this case started. In fact, the person you heard there speaking to us was Osman Al-Hassan, a legal team member for the MP. And so today was the day where all of the parties involved in this matter were expected to file their written submissions so that the judge was going to tell them or announce the date for the judgment. And so it so happened that 2 applications had to come from the respondent lawyers.
So what then becomes of the case? When can the judge declare the date for judgment?
Well, so that will be after the determination when the court reconvenes on the 18th of May. After that application has been dealt with, then the judge will decide that, well, everything has been cleared, all parties are satisfied, and so the announcement of the date would come.
Richard Kojo-Nyako, thank you very much for joining us this afternoon.